Good morning. May it please the court, John Stoll on behalf of the appellant. This case comes to the court as a result of counter motions for summary judgment on the issue of uninsured motorist coverage. The trial court granted the insurance company's motion for summary judgment and denied the insured's estate. The facts in the case revealed by those motions for summary judgment are very straightforward. In August 2005, the insured applied for initial coverage of $100,000 bodily injury liability and waived uninsured motorist coverage. The premium renewal notice for the policy to be renewed was sent out timely. However, it did not include a notice to the insured of his options of uninsured motorist coverage upon renewal. The policy was renewed, and during the first period of renewal, he died as a result of a motorcycle accident caused by an at-fault underinsured driver. That motorcycle was not insured under the policy. The trial court held properly that he was a Class 1 named insured for the purpose of uninsured motorist coverage. Consistent with the decision of the Florida Supreme Court in Mullisman State Farm Insurance Company, that entitled him or his estate to uninsured motorist benefit coverage if the policy provided it for injuries wherever or whenever received. So the fact that he was on a motor vehicle not insured under the policy did not deny coverage. It's only the policy itself that is at issue.
The issue here is whether every time that you correct me if I'm wrong, every time you send out a renewal notice or a premium notice, whether you have to include the uninsured motorist waiver. You have to offer uninsured motorist to him.
Correct.
Okay. Are you kind of asking us to read some words into the statute that are not there?
Absolutely not, Judge. I'm trying to ask the court to construe the statute as law requires. Our decisions of the appellate court require to be construed broadly so as to ensure that the insureds of Florida receive the maximum coverage under their policies. The statutory language is twofold. One, under 627.7271, the insurance company is required to notify the insured at least annually, and that's the key phrase, of his options of viewing coverage upon renewal. And that notice, pursuant to 627.6277 sub 2, is required to be attached to the notice of premium due upon renewal that is required to be sent out 30 days in advance of renewal. It is our position.
But the statute, I'm playing devil's advocate here, but the statute did not say that every time a renewal notice goes out, you have to offer the uninsured motorist again, does it? I mean,
It does not clearly say that, correct. But it doesn't say, as the trial court in Progressive contends, that notice is to be submitted only annually.
So what's your understanding of the language, at least annually?
The legislature clearly contemplated that there would be opportunities and instances in which more than one renewal would occur on an annual basis. And that's why the term was used at least annually, not annually, or only annually. By a broad construction as required, and I cite the decision of the Florida Supreme Court in Young versus State Farm, by construing that phrase broadly so as to ensure coverage for the insureds, it contemplates that the notice will be sent out upon each and every renewal, regardless of the policy period.
I think in order for this court to engage in that broad construction that you're suggesting, wouldn't we really have to add language to the statute? I mean, it simply says that the notice has to be sent out at least annually, quote unquote, and that the notice has to be part of or attached to the notice of premium, which to me speaks to the means of delivering the notice of UN coverage options, as opposed to the timing. The timing is really only governed by the language that says at least annually.
Judge, I would disagree with you because the statutory provision for the premium renewal notice requires that premium renewal notice be sent out 30 days in advance of expiration of the current policy. So clearly, the statute requires a premium renewal notice to be sent upon each renewal, not alternative renewals.
But where is the language in 627.7271 that says it has to go out with every renewal notice?
It's only by construing the two statutes in peri materiae that you see that there is a scheme of the statute that requires premium renewal notices 30 days in advance of every renewal, and 627.727 requires that options of coverage upon renewal be attached to the premium notice. So you cannot look at each of the separate statute provisions and conclude that the statutes require options on renewal in every instance. You have to construe the statutes in peri materiae in order to arrive at that conclusion. And peri materiae is the standard of Young from the Florida Supreme Court, in which Progressive then attempted to use two separate but contending independent statutes to arrive at their result of no coverage. The Florida Supreme Court said that thou shalt not do so. You shall construe these statutes in peri materiae to achieve a consistent and logical result.
Counsel, in your brief, you indicate that the Florida Supreme Court's opinion in Mullis versus State Farm Mutual Auto Insurance Company compels this court to reverse the trial court and remand the case to the trial court with directions to enter judgment reflecting that Beckmeyer is entitled to coverage of $100,000. How does the Mullis opinion compel this result?
Mullis, in 1971 decision, established the Class 1 versus Class 2 distinction for insureds who have received policies under stacked uninsured motorist policies. The consequence of the violation of failing to include the notice on this first renewal is consistent with Hires in this court's decision in Patterson. The consequence is that the policy is reformed and construed as a stacked policy as a consequence of the statutory violation. And because in Mullis, as I contend, that he was correct, the insured was correctly determined to be a Class 1 insured, then unit benefits extend to him for his estate for the injuries that were received while operating a vehicle not insured under the policy. Mullis, of course, requires that the unit benefits extend on the Class 1 insured to a person injured Class 1 insured, injured wherever or whenever. So under Mullis, you could be riding a motorcycle, you could sit on the couch in your living room, or operating another vehicle not insured under the policy but receive the benefits of stacked coverage.
Did the trial court in this case, though, didn't the court make that determination that the gentleman who died in the accident, the insured, was in fact a Class 1?
Correct.
So that's really doesn't appear to be an issue.
Except for the result of this court's review. Because he is a Class 1 insured, we contend that the statutory violation requires reconstruction of the policy, reformation of the policy, to provide stacked uninsured motorist coverage. And because he is a Class 1 insured, then his estate receives the benefits of that coverage.
Okay, but I guess in essence for us, or from the way I look at the case, really the issue here is how we construe the language, the statutory language relative to the timing of the notice of the coverage options.
Correct, absolutely.
That's really the issue.
Now, at the trial court, Progressive took the position that there was no cases that required that the statute be construed as we contend. And we cited to the court. The trial court didn't understand that because at the end of the hearing, the judge looked at me and said, isn't there a case out there that requires this notice be attached to each and every premium notice? And I said, there is. And we've already cited it to you. It's the Durham decision. And Durham is not the classic appellate holding. The issue in Durham was a different one in which there was two separate policies, and Allstate's computer caused two policies to be written for 5 vehicles. And there was a proper selection or waiver of human coverage under the first policy that had 4 vehicles on it, but there was none under the second policy. And the insured there contended because there was no election under the second policy, they were entitled to stacked uninsured motorist benefits as a result of the statutory violation. Durham held that those are actually one policy, the insured knew it, Allstate knew it, and it's not an appropriate result to view that separate policy just because of computer problems at Allstate as a separate policy.
Did that case,
Now,
the court in that case hold that the notice that you're complaining about today has to go out with every renewal notice under the statute? Was that a clear holding in that case?
It was not a clear holding. It was.
I don't think it was a holding at all. I think it was a comment.
I think it was a comment.
Exactly.
Only. But again, before the trial court, before this court, I bring to your attention, this is the only case in Florida that has squarely addressed, though not in the classic appellate posture of the holding, as to the construction of that statute.
Are there not other cases out there in which the courts refer to annual notice? Annual notice.
Correct. And one that's not in the briefs is Progressive, Izagiri versus Progressive. That was a commercial policy, and that was an annual policy. And the term in the opinion in Izagiri versus Progressive is this annual notice. But in the context of that Izagiri case, that was a one-year policy. In this instance, though, Durham was a 6-month policy. And the following language, even though not a holding, is appropriate. Twice a year, Allstate provided notice required by the statute. It wasn't dispositive of the issue, but again, it's the only appellate opinion in Florida that I have found that addresses or comments upon the issue. So we go back to the original argument.
Even that language that you're reading says, well, Allstate did it twice a year, and they provided the notice, the type of notice that was required by statute, not that it has to be done twice a year. I mean, even the language you just read doesn't seem to specifically address the issue that we're dealing with here.
The following appears, and I quote, twice each year thereafter, Allstate provided the notice required by section 627.727.
The notice that's required at least annually.
Correct.
The type of notice, I mean, it has to be a certain, in a certain format, so that might have been what the court was referring to there.
Now, if this court were to hold, as the trial court did, that
just so you know, I'm sorry, we're down to about 2.5 minutes. I didn't know if you wanted to say that very well.
Yes. Thank you. Thank you.
If it's the court, Your Honor, this factual situation here is not in dispute at all. It was an appropriate case for cross motions for summary judgment and appropriately decided by the court below. This policy was purchased in August of 2005 and given a policy number by Progressive. At that time, the insured, Mr. Beckmeyer, rejected the under the form approved by the state of Florida. That's in the record at 49. The policy renewal notice was sent out in January 2006 to be effective for a term starting February 28, 2006. And then the same policy number was given, and the way they distinguish between the renewals is they add a -1 instead of the -0. And if he had survived and gone on to have more policies, it would have been -2, -3, etc. The declarations page for the renewal said that there was no consistent with what Mr. Beckmeyer had chosen for his first policy, had rejected in his first policy, and had done in prior policies as well. The was not requested at any time by Mr. Beckmeyer or anyone on his behalf before his death. It was implied in the argument that there was maybe some legislative history that dealt with this, and I want to say that it's not before this court that there's any legislative history that says anything other than at least annually for the notice that's required with the renewals. The plaintiff's emphasis there is misplaced. There's no court case, there's no legislative history, there's nothing to support the plaintiff's interpretation of this statute. While public policy does favor coverage, the legislature has provided an unambiguous statutory scheme that's very difficult for insurance companies to follow.
Well, counsel has relied on the Mullis case for the proposition that we should broadly construe these statutes in favor of the appellant. Why should we liberally construe the applicable statute in the appellant's favor?
In liberally construing statutes, this goes beyond that. This is not a fair interpretation of the statute before this court. The Mullis case, yes, provides that if he was covered for under this policy, then he'd be a Class 1 insured and entitled to coverage. It does not address the issues before this court today at all. As a matter of fact, there are no cases out there that address this issue because the statute is very clear. The one case that has been cited for the proposition that this statute provides for twice-a-year requirement of notice is this Durham case that Allstate from the 5th DCA, and your honors are all familiar with the language. In the factual statements of the court, it says in 1991, however, the Durhams expressly rejected this coverage in writing. Twice each year thereafter, Allstate provided the notice required by Section 627, 727.1 Florida statutes. Just because Allstate didn't make it a requirement under the law. There were many other cases where they talk about annual statements and annual renewals and giving notices. This is just part of the factual background. It's not even a comment on the law. It's not dicta. It's not the holding. The holding in this case was that when you add a fifth car to a policy, and Allstate had a policy at that time that if you had 4 cars on a policy and you added a fifth, it had to create a separate policy number. The question was whether you needed a separate rejection waiver in order to make the rejection on the 5th car. And the court held that it was all one policy, even though it had 2 policy numbers, and the rejection stood. Certainly in that case, had they wanted to liberally construe this statute, they would have granted the plaintiff's request and given in that case.
Now, you said earlier, you made the statement that, or acknowledged anyway, that the public policy in this state favors uninsured motorist coverage, and I think that's why the particular statutory provision that we're talking about is written in such a way as to say to the insurers, you're going to provide this coverage unless the insured waives it or rejects it in writing. So why, if that is the policy, public policy in this state, why are you saying that the legislature then says, if your policy renews every 6 months, well, the insurance company only needs to let you know about coverage options once a year?
Well, because the legislature could have very easily said each time a renewal notice is sent, you are required to send form under this statute. They didn't do that. They said at least annually. If we had billed the individual monthly and renewed the policy on a monthly basis, and we would then be stretching it even further to its logical conclusion that at every premium notice, it's just a situation where it was very easy for the legislature to go in and say what they meant. They say at least annually. That to me means, there's no requirement of more than annually. I don't know that there's any other fair interpretation of that. Judge Mitchell below, read that the same way. Judge Dean Johnson, in a recent case, read that the same way. And I don't think that you can fairly construe this provision to read any other way. The legislature did understand that even with these renewals, and earlier in 627, 727, they talk about whether you don't need another written waiver in supplemental, which renews, extends, changes, supersedes, or replaces an existing policy. So they recognize that you don't have to go back and get a written waiver every time. You just have to give notice to the insured, at least annually, that they have this option. Mr. Beckmeyer, in his expressions under this policy, in signing the written waiver, in paying the premium, in getting the declaration page, the only thing before this court is that he didn't want coverage. We would be creating coverage where coverage wasn't paid for and didn't exist. To me, it's against public policy to do that, to create coverage where it doesn't exist.
I know you may not be able to answer this question, and I know this information isn't in the record, but what is the industry standard on this? I'm thinking about it from the perspective of someone who has car insurance, and
Yeah.
not necessarily with, any
I
particular, I'm not
can't
going to
say
name
what-
the company, but my policy renews every 6 months. Shouldn't I, of course, I shouldn't say of course, that I choose UM coverage, but if I didn't, isn't it in keeping with Florida's public policy that I be reminded every time I go to renew?
If the legislature said that it would be, I don't know what the industry practice is from insurer to insurer to insurer. I can only tell you what was being done in this situation. This wasn't something that was missed by Progressive. This was something they were trying to follow the law. They followed the law by giving this particular notice annually. Now, obviously, the policy that Mr. Beckmeyer would have had talks about UM coverages, talks about UM exclusions. The waiver that he signed talks about that, and annually he would get this separate notice that would accompany his premium. The Evans case was a case out of the first DCA where an ex-husband had signed the waiver, and then when the wife went to take the husband off the policy, this court held that even a signed waiver wasn't required then. Clearly, they would have received a premium notice at that time. Accident was 5 months after renewal. The court stated it was not obligated to offer UM absent a written request for coverage. That, to me, is more of an egregious situation, and this court still didn't go and say the insurer had to provide UM coverage. And in a similar case last year, O'Brien v. State Farm, this court also, Judge Wolf, you were on the panel, interpreted the same statute but didn't require an umbrella policy that there be a rejection form every time a new vehicle is added. If anything, the statute is more ambiguous about that than it is about our current situation. So, to me, I don't know that you can read anything but requiring an annual notice in at least annually. This Durham case does not apply in any way, shape, or form, and the statute is clear, which is our feeling as to why there is no other cases out there.
Thank you.
Mr. Parsons, in response to your question about an industry standard, I wish there were. We did depositions yesterday in a Progressive insured case, which was sent out every 6 months, premium renewal. That was a case that occurred in 1999. In another case, we took the deposition of General Counsel for Progressive, who stated...
Okay, your opposing counsel is standing up, and I think he wants to object. We're talking about stuff not... We don't allow objections in the appellate court, but...
I'll withdraw. Strict compliance with the statute is the standard. This court in Patterson cited hires, both had the same fact pattern.
So, counsel, if we agree with you, to reverse the trial court, holding that the professor should have given the notice, then what direction should we give the trial court on remand?
Because the facts are very clear on this case that the notice was not attached to the premium renewal notice, Patterson, decision of this court, hires require that the policy be revised as a result of the statutory violation to provide stacked uninsured motorist coverage. And because...
Aren't there still liability issues still to be determined by the trial court in this case?
There was no pleading that addressed whether or not the damages were less than or greater than $100,000. There was no pleadings before the trial court that claimed that Mr. Beckmeyer was at fault for his own injuries. The pleading only before the trial court was to review the policy provisions and determine whether or not it was a stacked uninsured motorist policy or no uninsured motorist policy, and that would be the demand. Demanding for construction that it was a stacked uninsured motorist policy. The issue of entitlement to the proceeds and benefits of that coverage remains before the trial court. Evans, as suggested, does not address the issue. There's a comment factually that the UM notice was not provided. However, the issue was not raised at the trial court and was not raised before this court. Rather, it was a separate issue contending that it was a new policy requiring a new election. Thank you very much.